Employment law basics. So recruiting staff is obviously a really, really exciting part of a business, and it's exciting to know that you are kind of growing and breathing new life into the company, but it can be like a really frightening time as well, because you're suddenly subject to this whole area of legal regulation that you were never previously familiar with. And because obviously in the tech sector, your kind of talent at the moment, the amount of it is a bit lacking. You have more demand than you have supply. Finding the right people and keeping them is probably more important than it's ever been. Obviously, during the kind of the course of the employment relationship, there's lots and lots of obligations that you're subject to, and also there's important questions about what happens when you need to bring that employment relationship to an end. This section is just really focusing on some of the kind of common pitfalls that we see when working with startup businesses. And because it's such a kind of broad and complex area of law, obviously we're only kind of touching on some of those issues today. So one of the questions I get asked quite a lot is, do I really need an employment contract? And particularly when you're sort of starting a business, it's not your priority issue. And I completely, even as an employment lawyer, I completely understand that it can't be your be-all and end-all. So the majority of employment relationships will start with an employment contract, and obviously this is a really essential way of establishing and protecting the employer-employee relationship. And it's just as important that your staff have employment contracts if you've only got 3 members or if you've got 300,000 staff members. In theory, an employment contract doesn't actually need to be in writing. But there is a piece of legislation that says that once you've had an employee with you for 2 months, they have to have basic employment information provided to them. And those are the things that I've highlighted here. So they need to know who their employer is, kind of quite helpful. They need to know what date they're starting. They need to know what they're being paid. They need to know about holiday, sickness. Collective agreements is about sort of trade union relationships, generally not as applicable in your sector, but all the same. Notice period, what happens if they're off sick, those sorts of things. So those are statutory minimum pieces of information that have to be included in an employment contract. Now, that kind of deals with the strict legal obligations. So once someone's been with you for 2 months, they have to have this in writing, a statement in writing. But what it doesn't really deal with is how an employment contract can kind of protect your business and work for you a little bit more. So, which leads me to what happens if you don't have an employment contract at all. So there's an employment tribunal penalty. So someone could, if they already had an existing claim against you, they could go to an employment tribunal and say, I haven't been given a contract, and an employment tribunal can award them between 2 and 4 weeks' pay, and pay capped at £450. So somebody could, in theory, and it's not a standalone claim, it's only if they've got another claim with you, they could come in and sue you for £1,800, a maximum of £1,800 for not having a contract. Now, what's actually the really kind of greater risk than that is the kind of lack of clarity over the terms and expectations that you have if you don't have an employment contract in place. So if you imagine a scenario where you've got somebody and you've said, well, my expectation for you is that you're going to work 9 to 5, Monday to Friday, and we're going to pay you an hourly rate. You don't have an employment contract with them because you trust this person, you know, you've known them a long time, and it's all kind of done on a bit of a handshake. And then that person says, do you know what, last week I worked all Saturday, so I want to be paid for that now, please, because I get paid an hourly rate, and I worked on my Saturday, you know, watching Match of the Day, doing a bit of work, and now I want paid for it. And you've got absolutely nothing to say, well, no, hang on, we didn't agree you would get overtime. We just agreed that you work Monday to Friday. If you're doing additional hours, that's something, you know, you need to be discussing with me. You've got no protection and nothing to fall back on if you don't have any of this established in writing from the outset. You've also got a likelihood then that you're going to have more disputes with that employee because you haven't specified what those terms and conditions should be. So it's important to have that contract in place. Now, one of the things that I see happen quite a lot is when you start in a business, and obviously a lot of the time funds can be quite tight, is that you go onto the internet and you type into Google employment contract, download, and you get a kind of pro forma and you fill in the blanks and you go, great, done, employment contract, big tick. Now, having a contract off the internet is better than nothing. But what I will say is that it will generally only cover the most basic information, and it won't do the job that it needs, particularly as your business is growing, to protect you where it needs to protect you. And quite critically, one of the issues is around confidential information. So in your businesses, I guess more than ever, your key assets are your information and your knowledge of the people that are working in that business. Now, in terms of confidential information, you would think that it would be obvious that if you're an employee, you shouldn't really go off to go and talk to a competitor and say, hey, do you know what they're doing down the road with my guys? This is the stuff that they're working on. You would think that that would be kind of implied. Well, it isn't. So the leading case on this is one called Fessenda. And this was a guy this was a sales manager, and he had a chicken business. You can see the guys in the back going, chicken business. And it's an amusing case for us because in the chicken business, his name was Mr. Fowler. No joke, his name was Mr. Fowler, and he works in a chicken business. Now, he resigned after...
Doesn't take much to entertain.
This is all we've got. Very simple. So he ended up resigning because he got caught stealing 45 chickens from his business. And he got caught and he got charged with theft. And a few months later, he went down the road and he set up his own chicken business, and he was selling chickens out of the back of a refrigerated van. And he thought, you know what? They were a good guy. I'm going to recruit them from my old employer. So he went and got a few of his staff, got a few of the best staff from his old employer. They're going to come and help me sell chickens out the back of my van. And you know what? I also know some of the sales information. I know who they used to sell those chickens to. I know how much they used to sell them to. I know what contracts they've had, how long those terms last for. So I'm going to take all that information as well. I'm going to set up my business and I'm going to compete directly with my old employer. Funnily enough, his old employer were not that impressed with this. So they sued him and they said, no, you've breached our confidential information. You can't go and do that. And they lost. Because actually, they had nothing at all that would protect them, nothing that told that person that we consider our sales information confidential, nothing that said that you couldn't go and take off any of our employees if you wanted when you leave, nothing that said you couldn't join a competing business. So actually, his old employer carried on and they just had to compete, knowing full well that Mr. Fowler was using all the information of their business in a competing business and presumably doing quite well out of it. So if ever there is an example of a case, you just have to think of chickens, of having an employment contract and having in that contract details of what information do we think is confidential to our business and what your obligations are. So not only while you're employed by us, but also once you leave, that information must remain confidential. So a list in there of sales information, business information, customer list, client list, anything to do with your tech, your intellectual property rights, all of those things are things which your employment contracts should be protecting and which you won't get if you type Google employment contract download, as much as it seems like an easier option at the time. So that covers confidential information. And then the other point, which was also relevant in the Fowler case, was about restrictive covenants. So remember me saying in that case, Mr. Fowler went and took some of the staff from his old employer. So that's where restrictive covenants come in place. So restrictive covenants or post-termination restrictions are things which protect the business when an employee decides to leave. So typically they'll cover things like they might say, for 6 months after you leave our business, you're not entitled to go and join a competing business within a 5-mile radius. And the reason you're doing that is because you're saying, well, that person has got such knowledge and such information about our business and our plans and our business plans that they would be a legitimate risk to our company if they went and set up a competing business elsewhere. And what you can actually do in the employment contract is specify in there what terms are going to apply when that employment relationship comes to an end. And you can also say, we don't want you going and taking our top staff if you go and work and set up your own business. And we don't want you taking them to one of our competitors. And we also don't want you to deal with the same customers and clients that we have, or use the information that you've got about those customers and clients to go and compete with us. And those are all completely legitimate things that you can put in an employment contract to protect your business later on. So the problem, again, with the not kind of off-the-shelf contracts is that it doesn't tend to deal with restrictive covenants. And the covenants themselves, the way the law looks at them is that they say, well, we can't stop somebody from going and working in a tech business for the next 25 years just because it will be good for us. They say they've got to be no more restrictive than necessary to protect the company's business interests. So the court is really wants to see that they're kind of no wider than necessary to protect your company interests. What that means is they can get really funny over the detail. And if they're drafted kind of too widely, then it ends up they're not enforceable at all. So it's another kind of argument, and obviously we'd say this because we're lawyers, and I'm in particular, I'm an employment lawyer, so obviously I would say you should go and see a lawyer, but if you are thinking about putting restrictive covenants in the contract, then you should go and see a lawyer to make sure that they're as enforceable as they possibly can, so that when that relationship comes to an end, at least you know that as a business you've protected what you've already built. Okay, what's another? Oh, so then another point to include in your contract is a probationary period. Now this sounds really obvious, but one of the sort of the best pieces of advice that I can give you is to hire slow and fire fast. Because if you are keeping somebody on your books for longer than you need to, then what happens is that the longer they're with you, the more employment rights they accrue. So once somebody's been with you as an employee for 2 years, they have a right not to be unfairly dismissed. And what that means is that you get a whole extra raft of employment legislation on top of that person. That means that when you're trying to terminate their employment, even if they're rubbish, you basically have to jump through a load of extra hoops that you wouldn't have had to do had you dismissed them a month before they got 2 years service. So the benefit of having a probation period in there, and generally I'd say probably a probation period of about 6 months is generally about right, maybe with the option to extend it by another 3 months, is that it forces you as a business to look at your employees and say, is this person the right fit for us? Are they doing what they should be? Are they suitable? Have they got the qualifications? Are they performing? And it gives you a kind of focus, a deadline of, right, in 6 months' time, their probation period is going to be up and we need to make a decision. So often I see that people have just allowed kind of, not even bad eggs, but just slightly underperformers to continue to remain with them. And then it gets to sort of 3 years and they go, you know what, so-and-so, he's been rubbish for ages. You know, he's never quite cut it. And I go, right, okay, how many years services he's got? 3 years. Brilliant. Okay, well, now you have to go through a performance management process in order to get him out. So you've got to meet with him and you've got to give him objectives and you've got to wait for 3 months and allow him an opportunity to improve, and then you've got to give him a warning, and then he's got to have another opportunity to improve, and all of this regulation that you wouldn't really have had to do had he had less than 2 years service, and had you actually dealt with him when he started with you in the first 6 months. So really important if you have an employment contract, you have a new starter, is to have that probation period in there and actually do something with it. So assess somebody's performance and their ability within the probation period. And do you know what? If they're not any good, get rid of them then, because you've got a legitimate reason to do it. You don't have to go through all the faff that you'll have to go through when he's got more years service.
You can have a shorter notice period within the probationary period.
You can, yeah, that's a really good point. So generally you will say that within a probation period you could dismiss within a week's notice. Whereas as somebody, the longer somebody stays with you, they generally have a week notice for each year of service. So it gets more and more expensive to terminate employment the longer that somebody's been with you. Which brings us on to the, oh, this is jazzy, I didn't know we did this. So this is the basics of unfair dismissal. So this is the right I was talking about once you've got 2 years service. So there's obviously a whole range of employment law claims that can kind of be brought against an employer when things go wrong, but the most common one we see is unfair dismissal and discrimination. So this is the formula for avoiding unfair dismissal as much as we can. So the first thing is, if you're going to dismiss somebody, then you've got to have a fair reason to do it, but not just a fair reason, a legally fair reason. And there are only 5 legal fair reasons for terminating someone's employment. So misconduct, so they've done something wrong. Capabilities, that can mean sickness, or it can mean lack of qualifications or poor performance. Breach of a statutory duty, that might be something like they no longer have the right to work in the UK, so you can't continue to employ them. Redundancy, that's fairly obvious. And then some other substantial reason, which is basically anything which doesn't fall within here but is pretty significant and justifies them their employment terminating. So once you've got one of these fair reasons, you then have to terminate their employment following a fair process. And what's fair is kind of what a reasonable employer should do once having regard to all of these things. So employment law cases, ACAS code, so there's an ACAS code of practice on disciplinary and grievance procedures and loads of other materials on ACAS, which will help you kind of guide what you need to do when you're dismissing for any of these reasons. So say for misconduct, the ACAS code will say you need to meet with that employee, you need to carry out an investigation, you need to give an appropriate warning, they need to have a disciplinary hearing, and they need to be offered the right of appeal, all of these sorts of things. And assuming you've got the fair reason and you've got a fair process, hopefully you've got a fair dismissal at the end of it. Now you would think it would kind of be enough just to say he's hit someone. You know, he went into the office and he pinned somebody up against the wall and he hit them. You know, that's misconduct. How can I not just dismiss him for misconduct? How can I not just say, that's unacceptable, get out? And you would think that would be the case. But actually the law says, no, even if they're terrible and they've done something dreadful, you still have to go through a proper procedure with them. So you still have to meet with them, you still have to give them an opportunity to put their side across. So if you physically find somebody with their hands in the till, you still have to get an explanation for them, because they might be saying, oh, do you know what, I wasn't stealing, what I was doing is I was getting some money to pay for office supplies. And if you haven't met with them and all you've done is gone, you out, then obviously that's not a fair dismissal. Now, it also helps you when it comes to discrimination if you follow this sort of process. So discrimination is a separate legal claim. And the really interesting in inverted commas for lawyers, is that discrimination doesn't have any qualifying service. So somebody who's not even your employee can bring a claim against you for discrimination. So this means that somebody applying to you for a job could claim that they've been discriminated against. So my big word of warning here is around recruitment. So be really careful when you are trying to get somebody new for your business in the way in which you advertise your role. So what I have seen quite a lot, and sometimes tech companies can be worse for this, is using language which you think is kind of good and it's selling our business and it's what we're about, but actually ends up looking a little bit discriminatory. Now, you would think something like saying, we're looking for recent graduates. Sounds innocuous enough, doesn't it? But actually, the phrase recent graduates is potentially age discriminatory, because arguably the majority of people who are recent graduates are of the younger generation who have gone through school and have gone to university and have just come out of university. So somebody applying to you for a job in their 50s might say, well, I was never going to get that job because you asked for recent graduates. You clearly only wanted a young person in this business, and therefore I'm going to bring a discrimination claim against you. And then you're scrabbling around trying to explain why that person didn't get the job, when actually it's just because not enough thought was given to the advertisement. So these are the protected characteristics. So sex, race, age, disability, marital status, gender reassignment, religion, belief, pregnancy, maternity, sexual orientation. These are all the grounds on which somebody could bring a discrimination claim against the business. Young and vibrant company. I've seen that before. I've had to have a little call to companies before because they've actually used the word young and vibrant in their advertisement or on their website. It implies that you are looking, obviously, for a younger candidate. Energetic. You say, we're looking for an energetic candidate. And then somebody comes and applies to you and they're in a wheelchair. And they say, the only reason I haven't got that job is because you've asked for an energetic candidate. You never wanted anybody with a disability, did you? Or a long-term health condition. You can see how easy it is to kind of get tripped up completely, innocently, just because of the language that you're using. But that's what the discrimination legislation does. And because there's no service requirement, it means that even people who haven't yet applied for a job with you can bring a claim against you. And actually, there are some people who are serial litigants who scour businesses and adverts for this kind of language, apply for jobs they've got no intention of coming for or that they're not qualified for, and then sue companies and hope to get a settlement out of it. There's people that actually genuinely do that. And by not kind of giving thought to your language, you kind of open themselves up to that.
The converse, if you say I want someone with at least 5 years experience,
Mm-hmm.
10 years experience, you can do that, can't you?
Yeah, you can, because I guess that's slightly different because you can have experience at different ages. But even then, it's better to be kind of qualitative about your performance and qualification. So I want somebody who has done this before, rather than I want somebody who's had this many years within a business. That's a kind of safer way of doing it. Okay. Good. Also good news, the compensation for discrimination is uncapped. So if somebody was to bring an employment tribunal claim against you, there is no limit on the amount of compensation that they can recover from you, whereas unfair dismissal is capped at about £85,000 or 52 weeks pay, depending on which is the lower. So compensation is the one that discrimination is the one you really want to avoid. And then these are all the different types, basically, of discrimination that someone can bring. Should be one at the top there, which is direct discrimination. So somebody's... I was in the one.
I wasn't sure if that was...
Right, there you go. So direct discrimination is basically just being treated less favourably than somebody else, so not getting a job when other people have. Indirect discrimination is where you've got a policy you're applying to everybody, but some groups are disadvantaged. Victimisation, treating somebody badly because they've made a complaint of discrimination. So if they raised a grievance and then you sacked them, that would probably class as victimisation. Harassment, so people making sort of derogatory comments in the workplace. And then the other two relate to if you're employing people with disabilities, you've got a duty to make reasonable adjustments to them for them. So that might be things like improving access into your workspace. It might be helping them with screens to combat certain visual impairments and those sorts of things. Okay. And then finally, from me, is just some of the key employment rights to be aware of. So national living wage is increasing to £8.21 an hour from April. And then some other sort of statutory basic rights. So notice pay, 1 week for every year of service. Holiday, so full-time holiday entitlement is 28 days, which includes the 8 bank holidays. Statutory sickness pay and other things about sort of working time. And the important thing is that those are the statutory minimum conditions. So even if you agreed in your employment contract to do something else, you can't contract out of these minimum requirements. So you might have a kind of deal with somebody, maybe it's like a skill swap, or you have an informal arrangement with someone where you go, can you just come and do a few hours doing some, software development for us? And you say, it's a bit of a favour, I'll help you out, you help me out. Let's not make it formal, there's no payment needs to change hands, we'll just do it between us. If that person is working full-time for your business, they're entitled to the national minimum wage, or they're entitled to the national living wage. So you can't agree not to pay somebody, even if that person says, yeah, all right, that's fine, because later down the line, they could come back and say, do you know what, you've not paid me for the last year, and, I worked 50-hour weeks and I didn't get anything at all. That person has a statutory entitlement to be paid, so just don't get caught out by being very informal with your employees. So that's it for me. I guess as a takeaway, your employees they make or break your business. So it's taking the time to safeguard the company in the way you firstly in the way you recruit them, and then the way you retain them, and ultimately the way in which you kind of part ways with them.